Rachel. Hello, everyone. I hope that you can hear me. I'm going to stop share the screen. And I'm going to pin us is everyone able to see us in the room here? Just give me a thumbs up or put in the chat. Awesome. Well, thanks so much, everyone, for coming to the C21 conversation today. Anne just gave a welcome, but I'll welcome you again. My name is Nicole Welk-Yeager. I'm the Deputy Director of the Center. Anne Basting here is the director. We had this conversation points come up to us by two wonderful faculty members from our Reproductive Justice Collaboratory who will introduce themselves as they facilitate this conversation. And we're just so grateful to have everyone here to have it today. So with that, I leave it to Maria and Rachel to start going.
Welcome. So thank you everyone for joining. I'm Maria Novotny, and I admit I have a cold. It is not COVID, it's a toddler cold. So if I am coughing or need a break, Rachel will hopefully help step in for me. But as Nicole and Anne mentioned, I'm an assistant professor of English here at UWM, and a lot of my work deals with infertility, rhetorics of infertility, but specifically also access to fertility treatment, and then also access to donor embryo options and a lot of decision making around embryos. So that's a little bit about myself. Rachel.
Hi everyone, I'm Rachel Bloom-Pojar. It's so nice to have you all here with us. Yeah, I'm an associate professor in the English department working with public rhetorics and community engagement. I am, I guess, what one would call a community engaged researcher. My work looks at confianza or trust and confidence in relation to Latinx rhetorics of community health and reproductive justice. Specifically, I've been partnering for the past 3+ years with the Promotores de Salud, the health promoters who are affiliated with Planned Parenthood of Wisconsin. So they do community sexual and reproductive health education. And yeah, I'm just grateful to be a part of the conversation today.
So like Anne mentioned very briefly, and I can just kind of recap, a lot of the exigence of this conversation came out of the summer, both pre the Roe reversal and then also post the Roe. So Rachel and I started this collaboratory, the Reproductive Justice Collaboratory, in January of 2022. Simply because we were already doing a lot of this work in this area and wanted to collaborate across campus with a lot of other individuals who were also interested in this. But then also we created it honestly with the anticipation that news would be coming at some point in the summer, right, with the Dobbs decision. And so out of this, we decided that we really needed to have a conversation that explored what it means in terms of our own research. So we know that there were a lot of conversations, and there are still a lot happening across the UW system, which we're really grateful for, about what this means in terms of students and what they can access, the types of support that they have, as well as employees and just their own access to various types of care. But for us as researchers, and particularly humanities researchers who are constantly, I would say, aware of the increasing socio-political rhetoric that is threatening of certain positions, right? We wanted to kind of know a little bit more from other stakeholders at the system level and here on campus about what are some resources, what are some tools, what questions can we get answered now to help ensure that we can continue this work that we both are really committed to. And also to create a space really honestly for you all here who also are committed to amplifying this issue and also supporting this type of work across campus. So because of this, Anne and Nicole, we're really grateful in having Sam and Donna here today. So Donna McGee over here, right, is currently UWM's Deputy Chief Legal Counsel, has worked at UWM in the Office of Legal Affairs for 17 years. Among other things, Donna advises on research-related matters and regularly partners with UWM's Office of Sponsored Programs, Research, Strategic Partnerships, and the UWM Research Foundation. So thank you, Donna, for coming today.
Having me.
Yeah, Donna, so what we'll do after this brief introduction is Donna and Sam will then kind of showcase and talk a little bit more about their own expertise that they can offer to this area. And then we have Sam. So Sam Westcott, right? has been a research administration for 30 years, and she came to UWM this August. So welcome. I'm relocating to be closer to family. And she has worked in the administrative and financial aspects of research at Caltech, is where you were, right? And now she's also actively involved in professional development with the National Council of Research Administrators, and supports the Office of Research. So a very important person to have here. Thank you.
Thank you.
So for those who are joining virtually, I think Nicole sent out or has shared a very brief visual, but essentially it has an agenda. It also really points to 3 thematic focuses that we had for this conversation. And we really want to focus a little bit on the academic right to free speech in post-Roe. What can we say? What can we teach? What can we share in terms of resources? And then related to that a little bit are the limitations then to conducting research related to reproductive health. So navigating, for instance, reproductive health community partnerships. This is something, for instance, like Rachel's work touches on in particular. And then other resources available surrounding protections, right, for scholars, given, like I was mentioning, increased hostilities surrounding higher education and potential threats when working with these communities who may, for instance, identify as LGBTQ+, may lack citizenship, or also we're working with individuals who are actively seeking medical care outside of state lines for various reasons. So we basically sent these thematic areas to Sam and Donna, along with a list of questions. I won't go through all those, but those questions are on this handout, with the hopes that they could provide some information on this, and with the caveat that this is all new territory and that there will be a lot of unknowns. And so we built in, after they presented some initial information, we'll take some general, basically have an open forum for people to also voice their additional concerns, questions, and whatever degree you feel comfortable doing so. But then also acknowledging the precarity of this, Rachel will help us kind of have a conversation about, given these unknowns, where do we go from here? How do we map a future research type of trajectory given this? Am I missing anything?
There's just 2, you're not missing anything.
Yeah,
2 things I just want to add that I think you touched on, but I just want to emphasize. We both mentor and work with a number of graduate students that are very interested in this area. So part of our interests are not just personally, but also how do we guide new emerging researchers and help them know what sorts of risks they might take with taking on this kind of work. And then the other thing is, when Maria mentioned increasing awareness of the socio-political landscape, I think it's relevant to share that we also were co-PIs on a recent toward an anti-racist campus program and seed grant. And as far as just also being a topic, say critical race theory, which very much is in public discourse about what should and shouldn't be happening in educational settings, even so much to the point of being interviewed for a newsletter about the work we did by a campus granted program. And the person interviewing us expressed some concern about some readers being not sure if they were supportive of us doing this work on campus. So we come into work with reproductive justice with an awareness that there are different types of people in the university and other community who have thoughts on what should and shouldn't be happening. And so we just appreciate this space to connect with others who know or are engaging in similar types of questions, to also have a better sense of maybe like community in this type of work. So thanks, yeah, and then I think we can turn it over to you two, right?
I think I'm going to start.
Yes,
The plan. Hello. I see some familiar faces that I've worked with in the past. So I thought it would be helpful if I just took a couple of minutes to kind of map out just the legal landscape, both on the federal and the state level, to kind of make sure we're all on the same page or have the same sort of background knowledge. And then just in kind of looking at the themes and the questions, I was then going to focus on academic freedom a little bit and what you can and can't say, including in the classroom, your syllabus, publicly. And then I was going to turn over to Sam, and we thought the other sort of area that might be helpful is if we talked about data and data protections and concerns with data, because I think, at least I'm guessing as researchers, that's what you're kind of worried about among many other things. And then from there, we can kind of tackle some of these other questions or questions that other folks may have. So with that, I'm going to launch in hopefully a brief overview, but as many of you know, we're here sort of to talk about Roe v. Wade, right? That was a Supreme Court decision that got passed, handed down in 1973. And that decision basically did three things. It recognized abortion as a fundamental right. It also recognized that states have some interest in potential life and thus have some ability to regulate abortion. And then it established a framework for state regulation, basically a trimester based regulation scheme. And the first trimester being no regulations, the second that there is a state interest in the second trimester, and the third basically you can ban abortions in the third trimester, but you need to take into account still the life and health of the mother. So there were still some exceptions. So then in 1992 came Casey. Casey did not overturn Roe, but there was definitely some erosion of the protections that the court talked about in the Roe decision, and Casey was 1992. And that case involved a Pennsylvania statute. And a statute that required a couple of things. Make sure I get this right here. Spousal consent to an abortion, reporting requirements, and then a 24-hour waiting period. And the Supreme Court said they still recognize abortion as a fundamental right in Casey, but they kind of elevated the state's interest in the protection of life or potential life. And they kind of tossed out the window the trimester framework and talked about viability. A lot of what does that mean, right? Like there's all sorts of discussions that were sparked from that. And they said basically the state could do a lot in terms of regulation, but did have some limits. They ended up saying the waiting period was okay, basically. That requiring parental permission for minors was okay as long as there was a court override, essentially the ability of the court to come in and say, okay, you instruct your parents in this case, we say, so that's okay. And then, but they struck down in that case the spousal. So then comes Dobbs, and that decision was handed down on June 24th of 2022, very recently. And that decision involved a 15-week abortion ban in And there's pretty much not much debate that there's no viability at 15 weeks. So the fact that the court took this up, I mean, it was pretty clear that it violated the previous provisions in Roe and in Casey. And so the fact that the court took it up definitely signaled to a lot of people that there was going to be some further erosion on abortion rights. And as you all probably know, basically the Supreme Court in that decision struck down Roe and Casey, which the effect is essentially to toss back the issue of abortion and abortion regulation to the states. And then we need to focus a lot more on Wisconsin law now. There were also, before I get to Wisconsin law, 2 executive orders. Just one second. That President Biden released. The first one came out on July 8th, and the second one came out on August 3rd. There's a lot in there, and there's a lot of, I direct you to kind of work on this. So I'm not going to get in the weeds too much on that, but did want to point out a couple of things that I think are more important for this discussion about research, data, kind of what you're collecting. So in the July 8th one, there was a lot about protecting patient privacy caused by the sale or transfer of sensitive health information, and also some stuff about digital surveillance related to reproductive health services. Sam's going to actually talk about that when we get to the data section in a little more detail. So again, a lot more going on in that executive order, but kind of, yeah. And then August 3rd, I think of note is a sort of edict to promote research and data collection on maternal health outcomes. And basically Health and Human Services was directed to evaluate and improve research, data collection, and data analysis efforts at NIH and the CDC. So interesting, right? There's this sort of mandate to kind of do more research in this area, but also sort of a lot of concern in light of the decision about doing research in this area, or how you do research in this area, right? So it will bring these questions up like more and more, right? If there's grants that are, so moving on to Wisconsin law, very interesting. actually, I should just point out in terms of, we're gonna sprinkle in some resources as we talk, and then we can kind of talk at the end of some other resources that might be available. But the Wisconsin Legislative Research Bureau, which sort of does what it sounds like does research and kind of issues paper. They do a lot of stuff, but and do research at the direction of the state legislature. They actually issued an interesting 10-page publication called The Brief History of Abortion Law in Wisconsin. If anybody is interested, it's sort of more than you ever want to know about abortion law in Wisconsin and about the laws that were passed. So that's just a resource out there for those that are interested. I hope to kind of sum it up though in less than 10 pages here. So essentially what happened with the Dobbs decision is, again, sort of we moved back to Wisconsin law, and there's a Wisconsin anti-abortion law on the books from 1849, prior to when women had the right to vote, on books, that makes it a crime for a person to perform an abortion, except when necessary to save the life of the mother, which is different than the health of the mother, and does not contain an exception for pregnancies resulting from, for example, incest birth rates. So that's the law that sort of arguably has sort of sprung back into being. And so what happened is when Roe came down, essentially that law became unconstitutional. So it wasn't enforced from 1972 forward. So then what happened is Wisconsin passed a series of laws sort of further regulating abortion kind of in the spirit of Roe and Casey, right? Where they could put restrictions. The court said you could put restrictions on this if you are states. So there's a whole bunch of these laws, but basically there are laws in the books in Wisconsin relating to waiting periods, the requirements to put certain information in writing to individuals seeking abortions, required exams and ultrasounds, and some rules regulating medication abortions in Wisconsin. Actually, they can only be performed by a physician. You can't sort of get a pill and take it at home, even pre-Dobbs in the Wisconsin landscape. So then there are now questions about what is good law in Wisconsin as it relates to abortion. And the answer is, well, sort of a little unclear. So shortly after the Dobbs decision, Governor Evers and his and AG Cowell, they filed a suit basically challenging the 1849 law under a theory that, well, you have all these laws and they technically conflict with each other. You have this old law that says you can't perform any abortions, and then you have all these post 1972 laws that say, well, you can, you just can only do it this way, right? And so that lawsuit is pending. Basically, they're arguing then that 1849 law should disappear, and the ones that should be on the books are these other ones, right? And so what does that mean? Well, we don't know yet, really, but what it really means is that anyone that was providing what are sort of referred to as elective abortions stopped doing it in Wisconsin because of the obvious legal risk. And that Planned Parenthood, they stopped performing abortions in 2022, and we don't think there are any other providers providing abortions that are, again, elective. And now I'm not sort of an expert on the medical terminology, but in Wisconsin, it is still legal to perform abortions that are necessary for the life of the mother. So there are hospitals that are performing abortions, and they have put in or are putting in place protocols for how to sort of make sure they're within the parameters of the law and that these are medically necessary abortions. But basically, anyone seeking an abortion that does not fall under that category will need to seek abortions outside of this. Well, yes, but I mean, people are interpreting this with the uncertainty. Nobody's providing them right now, so they do need to seek them outside. And then that could change when this decision comes down. I don't know when it'll come down, and we, of course, you know, we don't know what it would say or when it will come down or how they will rule, but it does highlight sort of what's going to be a theme by me today, which is there's a lot we just don't know. And there's a lot that's going to change in the near future. Just a couple of other notes on Wisconsin law. So the 1849 law does not contain penalties for the pregnant woman. So the individual getting the abortion would not be the one penalized under our law as it currently stands on the books. It is the providers that would essentially have the legal liability. And this is kind of different in every state too. So we're really focused on Wisconsin here today, but if you do work outside of Wisconsin, that definitely raises potentially other questions and concerns about the legal landscape. And then emergency contraceptive, which is also referred to as the morning after pill, that remains legal in Wisconsin. That's different than a medication abortion. That's considered contraception. And then, so our advice has been, if you're actually a medical provider in Wisconsin, is that you can't refer in Wisconsin for an elective abortion, although again, you can't really eat now anyway, because as far as we know, nobody's providing them, but you can refer to outside of the state if you're a medical provider. And I think that's where somebody's approached a medical provider about that, they can refer. So we're not here. So DOS itself, theoretically only, and I use that term loosely, right? It significantly impacts women that are seeking an abortion, and it fairly significantly impacts providers of abortions, right? It didn't change anything else vis-a-vis Wisconsin law at this point. I mean, it did sort of spring into action that 1849 law. So really, you know, what we're watching for, and it is sort of ancillary or future legislation, particularly in Wisconsin, because again, everything has kind of been cast back to the state. And there's lots of chatter nationally and in Wisconsin about, okay, well, what's going to happen? We don't know. We don't know what laws are going to get floated. We don't know what laws in Wisconsin are going to get passed. You know, things that people talked about, not necessarily in Wisconsin, are, you know, measures that would allow an individual to sue those who help people seek abortions in other states, right? Right now, it's not illegal in Wisconsin to refer people out of state for an abortion, right? But, you know, there's talk of laws banning leaving the state for an abortion. There's talk of bans on certain research on reproductive health or on fetal tissue use. And who knows what else I would say. I mean, right, like there's some creative stuff that I've seen or read about. And then, you know, I think I at least expect to see more on the Wisconsin front post the upcoming election. It's near. I think that some people might be waiting to propose legislation depending on what happens with that election. And we keep an eye on that system. UW system keeps an eye on legislation, any legislation that will impact potentially the UW system and UWM. You know, we have people in offices whose job it is to lobby and to talk to legislatures and interface with the governor's office about proposed legislation and what that impact may be on us, impact that they may not realize, right? Or impact that may be intentional. And so I guess 2 points there is just, I can't really predict, right, what's going to come down in terms of new legislation in Wisconsin, but certainly we would work with, as we always do with system, on any sort of education or advocacy or whatnot, vis-a-vis any impact that might have on the university itself or the UW system. So that's sort of my kind of spiel on the background, hopefully kind of bring everybody up to speed of where we are. There's lots and lots of nuance in there, nuance that I can't even really speak to necessarily, but yeah. Why
didn't the governor, as the leader of the state, call the legislature together in the summer and settle this question?
I can't speak to.
I mean, it just seems like that would be the natural, that would have been the just thing to do.
I don't know. I can't speak. I mean, the governor.
Well, you're closer. Well, you're closer to it than I am. Thank you. So, unless there's any other questions on kind of the legal case, I think I will talk a little bit about the academic right of free speech and kind of some questions that were sort of asked, or I think might be asked, or might be helpful to answer. So I think there's a lot of questions in this space. One is typically, can UWM employees speak out, against, or in favor of the DOPS decision. And for sort of all of this, with respect to kind of academic freedom and what you can and can't say, this is really no different. It may feel different. I know people feel strongly about it, but our advice in this regard is really no different than what our advice has been historically with respect to any topic or any, you had mentioned something earlier, I forgot, but also Black Lives Matter. People ask questions on critical race theory. Thank you. I thought, oh, that's another one, right? Right. And so our advice is similar. Again, even though people feel really strongly about this and should, if you think about it, it's sort of like any other sort of politically charged topic that you would be speaking or not speaking on, depending on what your job is. And so, you know, our general guidance on employee statements and advocacy, again, remains the same. So in terms of making statements or representing the institution, only the chancellor or his designee is empowered to do that, right, on behalf of the institution. And then if any sort of unit or subunit kind of wants to make a statement, it really needs to be in alignment with that. And so it was university relations, it's now kind of marketing. The university that piece of that is sort of cleaved off into MarCom, which is marketing and communications. They actually have a really good one page thing on their website that is called Statements on Current Events and Issues on their website that really kind of talks through this and is, I think, pretty helpful and kind of pretty succinct about if you want to make public statements, if you're a unit, if you're an individual. If any unit wants to make a statement, they need to be making sure they're talking with their dean or division head about it, and also then bringing it to marketing and communications to look at. They're super helpful. They're very good at their jobs and good at crafting messages too. That's what really you should be doing if you're making kind of school-wide statements or department-wide statements. Now, and the other thing you could do too is look up. Many of you probably are in fields where there are professional organizations. I always look to the National Association of College and University Attorneys because that's really helpful when all the university lawyers in the country kind of band together. So there are other ways too where some professional organizations put out statements that one way is we might be able to join those statements if they sort of answer or meet our needs. That's another option there. And then individual employees as private citizens can make private statements. You can, post private sentiments on your Facebook page or wherever it is, you can Instagram. You just need to be careful that you're making sure that it doesn't look like you're representing the institution and the institution's views, or sort of speaking on behalf of the institution when you do that. And then I think the last category is, what if it's your field, right? Your professional field is obviously, it sounds like in your professional field, that's why we're here, you raise this topic, right? So faculty can do that, or other people with expertise, but they should be presented as academic review and analysis. The site I talked about on marketing and communications website actually has some really good tips on there, and I've copied some of them into my notes, that they advise making clear you're speaking as an academic expert and not a spokesperson for a department at UWM, which I just talked about, to clearly articulate your academic qualifications and kind of stay in your area of expertise. Present comments as again, I said this, right? Academic review and analysis for public consideration. Avoid taking a political position in your role if you're as an academic, and then just exercise caution about actions or events that haven't yet taken place. And again, there's lots of moving pieces and lots of stuff yet to come on this topic, I think. UW's system also has, and I think it gets emailed out by the university every year, is guidance always around this time, actually, guidance on political activity, which is also very helpful, I think, because this really is, a lot of this is potentially political activity. And so it's always helpful to kind of consult that memo, if you have questions about that. And just one sort of word of caution. When you're engaging, so you can use it's built into our policies, right? Your email or your computer for what we refer to as incidental personal use. So, you know, I'm always like my husband, you know, oh, what time is swim practice? Like, oh, did you do these 8 things for me? Pick this up at the store, right? That's incidental personal use. And some other communications. I mean, I do plenty via email, right? But I would be particularly careful with your use. You're not allowed to use university resources for outside activities. So if you're doing any sort of lobbying, if you're working with any sort of groups on political issues, if you have another business on the side, you need to be careful that you're not using university resources. And I think email kind of trips people up a little bit because again, you're emailing all the time, right? And you're in your work email versus your personal email. But we are all as state employees subject to Wisconsin public records law, which means that anybody can request any employee's emails at any time. And there are exceptions in the law where we might withhold stuff, but those requests come into UWM's records custodian, and if she gets a request for X person's emails, she asks for them and looks at them and makes a decision whether to turn them over. And so I do think, you know, in that we've had requests when, you know, people find out, oh, she did a talk on this and I don't like this, and so I'm going to ask for all her emails, right? And so then you get requests for emails, and then it's like, oh, you're using your email to do all this political activity in violation of our policies, right? So just be mindful, particularly I think with politically charged issues, that you shouldn't be using UWM or state resources for that. And again, email, it applies to things too, like your computer, you know, fax machines. I don't know that anyone uses those anymore, but like UWM letterhead, right? Those are definitely, so just you know, keep that in mind.
How does that reconcile with the challenge of being a public intellectual?
Of being a public what?
Public intellectual. I mean, the public recognizes people as expertise when they're on the university faculty. Let's take it out of this role. You're a recognized expert on Mars, and you get emails from people asking you about Mars, to appear on television shows, to comment on scientific panels. Those things are not, strictly speaking, part of your UWM job, but they're also, but they're not part of teaching in the traditional sense, but they are part of being a public intellectual or public service. And people find you, and they don't write your private email.
And that's fine. It's fine.
And-
You
and-
can't control what's incoming. And I would argue that responding to a request to do some lecture series or something like, you know, my emails relating to this, you know, I think plenty of that is within scope for a faculty member that does research and is supposed to do service and outreach and advocacy. Like I'm more kind of, I think,
Not
talking about
advocacy, but expertise.
expertise. Yes. And I think you can, if you're being contacted sort of as a faculty member for your expertise, that a lot of that probably, or most or all of that, and it's really hard, right, without knowing the exact email or contact that's coming in. I do think that is often part of your, and that's not what I'm worried about in terms of responding to. I think I'm more talking about something that would take it out of the realm of your academic position and be more like, I'm a big advocate for Planned Parenthood. I'm going to volunteer for them. I'm going to speak at their, you know, lecture series in my independent capacity. That type of stuff, I think you should be, you know, using your personal private email for. There is, you know, there's gray, right? And that's what I'm going to say a lot today, that there's gray. Our office is always happy to consult too on issues where it's unclear. Did you have a?
Oh, I just wanted to clarify, like even if you were to be invited to Planned Parenthood, for example, due to your expertise.
It could be within scope, yeah.
As an historian or a political scientist, can you still use your UWM?
Yeah, I think, no, that's fine. And it's a little tricky and a little gray, right? But yeah, like you could be invited to speak even at Planned Parenthood, I guess. And it's hard. It's like really hard to think of examples off the cuff here, but like talking about stuff that you're doing in your independent capacity, like private personal capacity. Just hear that.
Yeah, I just wanted to note for those of you who are in the chat, there's some activity in the chat. One being to the point of the governor did call a special legislative session as per a comment by Kristen Pitt, saying that both houses kind of just like hashed it out, but didn't like actually resolve very much. And then there's also the question for those who are home or like doing virtual right now, if before you ask a question, if you could just state your name so that we can have the conversation happen virtually and in person. So sorry about that. That's just a logisticals of me trying to navigate online and in person here. So thanks everyone.
Well, you've consistently said, and you said that Marcom consistently advises to stay in the bounds of the expertise.
Yeah.
And I think that's where it comes from. And you could be asked to speak at a church because that's where they're
Yes.
holding an event, or it doesn't necessarily make you go in alignment with whatever that church professes as its creed. You're speaking at a place as an expert.
Yeah.
And I think that's where it comes
Yeah.
comes through.
I think university relations is actually pretty good with that, because for instance, with infertility work, I've been asked by reporters to comment on some, but it goes through university relations because I am listed as an expert
Yeah.
in that area.
And they're super helpful too. And if they are, I think that they don't know where the line is, they regularly can consult with our office too. But yes, good point there. But there was a lot of people available to sort of help. We think these model through this.
And thanks to the help at home for looking up the response to something we didn't know. So I appreciate that.
And there are also, just some sort of last bullet point on this section, is there's also lobbying rules in effect that we have to comply with. And so Marcom also helps make sure we have some individuals on campus that are registered lobbyists.
Yeah, and to further clarify, they didn't hash out anything really in the special sessions. They spent under 60 seconds and started the special sessions and then ended the session. So that's what happened.
Thank you. Whoever.
So I'll just note, I do appreciate hearing about the resources that we have, like legal consulting or a PR communications consulting. Maybe is something that we could follow up on, of like a list of resources for anybody who would
Yeah.
like to have that would be really nice.
I think that's a great idea.
Sam actually started to pull together because we saw that as one of your topics, some of the stuff we were talking about, but it's not in shareable form at the moment, but we're happy to pull that together.
So I was going to say, anyone who's here in person, if you don't mind, if we could, maybe on the back of my handout, if you want to have any follow-up resources, you can share your email with me and I'd be happy to follow up on that. And again, with anybody who registered online, we can do that as well.
I also note that I believe there are 2 graduate students that might be writing a blog about this too. So we can also share the resources on a few different other platforms. So
Perfect. Some other questions. I think some folks have wondered what, does this change anything working with external organizations? Again, from my perspective, not really, right? And there's 2 pieces of this. I think, we have contracts with some organizations to do stuff unless anything is contractually changed, which I think I was hard pressed actually to come up with an example. So I think it's unlikely that there is an agreement, but every time I say something like that, somebody, comes in and says, well, wait, I have this thing, right? So I'm always happy to advise on particular contracts or particular relationships. But, I think some other questions were raised about, well, does this change how other organizations want to work with us because we're a state agency? And my answer there is, we're no different than we were before, which is a state agency that has some restrictions on what we could do. That, like this is a political topic. We work on other political topics with other outside, folks. And so they're my sort of, maybe somebody, an outside organization just decides that they don't want to conduct a joint research project with us because of concerns about people asking for our data or whatnot. But in my mind, at least, we're no different than we were before as a state agency with our kind of quirks. State agency.
Can I follow up on
Yeah.
that real quick? So part of why I think I raised part of that question is just as an experienced researcher of navigating our system, I've learned things that I feel newer researchers might not be aware of. If, let's say you wanted to work with a community partner organization and compensate them because of funding that you have, we do have, I just think this is good for people to know, specific requirements of needing to report who gets that compensation. Social security numbers are asked for, home addresses are asked for, accepted with certain cases. If it's like an anonymous survey and you have IRB approval for that. And so I'm simply just putting that out there of any sort of emerging researchers who do potentially want or have funding, that it's helpful to know that, as you said, it's nothing that's changed. It's something we've always had. But I do think, let's say we had a humanities project that was asking people about experiences with access to care. There are certain mechanisms that their personal identifying information should not be shared, but is kept on file in case there's like an audit, right? About like the way finances are used. And so I just wanted to put that into the conversation.
Good, that's helpful, good point with not necessarily a good answer. Want to pose any questions? So just another couple topics I have some notes on is, questions about what information can instructors share in the classroom about reproductive health care. And my advice there is that, if you continue to share that, especially like particularly if you were before, right? But it should be relevant to course content, be part of your course materials, are based on facts or supported by research within the field. And so, again, my sort of advice would be similar, right? If you're talking about, and this was part of your class before, you're talking about these issues, you don't need to change that. And we've gotten quite a lot of questions about, well, can I tell people about abortion services that are available and whatnot? And my answer there again is like, well, were you providing health advice before? Because we don't really want people providing medical advice to our students that it isn't part of their job, right? And so if it's not part of your coursework or something you would regularly teach on as part of the course or your expertise, if students come to you with questions or whatever advice about actual where can I get abortion or how have things changed, our advice there is to refer students to the health center, where they can actually talk with a medical professional and get referrals out. And they're good at their jobs over there, and they're keeping track of where things are changing and how things are changing and where they're referring folks out to or whatnot. So I think with this topic, it's almost like a little bit of a red herring for folks, like, oh wait, now all of a sudden I need to do all this stuff differently. And sort of when you take a step back, it's like, no, wait, this is, and unless there's a specific law that comes down that specifically changes something, this is sort of, akin to other topics and how you would handle those if they arose prior to that. So,
That's a question.
Yeah,
just
sure.
briefly on that. I'm sorry. So, I'm just thinking about possibly putting in some sort of added statement about access to abortion services, for instance, just in light of, and I understand what you're saying with it, but I'm just thinking also in light of like COVID-19, like we all put in statements about where to go get tested, where to go find more resources. And that came down, if I believe, like from the UW system, or that there were statements approved. And I just wonder if there's any movement to approve some sort of statement about access to care, like system-wide.
I am not aware of one, no, and our advice has been, that refer people to Norris to not sort of just kind of put statements like that in your syllabi if that's not your area or what you would have done before. It's certainly something that could be raised. I think the COVID thing in my mind is slightly different in that was impacting our actual instruction. I don't know what that statement looked like, honestly. I'm sure I saw it at some point. But actually, that we were encouraging testing or masking, or that was a moving target too, and that some of that was related to our actual in-person instruction.
And the contact tracing of COVID was so critical, and now we're running up against this need to be able to protect people's information and where they get contact and what they're doing. And so it's almost like on the opposite side, and it's hard.
So we have a few questions and comments in the chat that I just wanted to plug in here that's all related. First, looking at Maria and Rachel, if you feel vulnerable with the work that you are doing and what specific concerns you might have. And I think that we're kind of like hashing those out now as we're moving forward. And then another comment, a lot of the research I mentor is undergraduate research, which takes place under the auspices of a course or formal academic programming. I wonder if there are any interesting or even helpful intersections with FERPA to think about. So here I'm thinking about protecting student researchers and faculty as the mentors of students doing independent projects as opposed to joining faculty research projects. So.
Yes, and that is on my list.
Okay.
That's a good segue, because we're gonna, like, this is
also-
when I was gonna start to
I
segue.
just have
Was there?
one
Oh,
question.
yes, sure.
Just like building on Maria and like I understand what,
Oh,
Casey, building on Maria's question and then like your response when you said how COVID statement was in there because it impacted our instruction. Is it not impactful to our instruction? If a pregnant instructor cannot get access to a certain thing and now is forced to go to a different state to get access to it? Or our students who could become pregnant?
I'm not quite sure how to answer that with my sort of legal hat on, which is, you know, yes, but I don't know the whole sort of background of how those COVID statements ended up in there, or so. And I don't think it's really, I don't know that anyone's considered that in a similar way to those COVID statements. I haven't heard this come up before, other than we had been giving guidance and, you know, system has, I think it's on the same page about not adding sort of statements to syllabus because we wouldn't do that for other medical conditions, although again, COVID. So I kind of would need to think that through, and again, I'm not even sure. Yeah, I don't have a good answer. I mean, I definitely understand your perspective, right? And that it is.
And thinking more along the, like we have the Accessibility Resource Center as a statement, like can like, you know, health and especially stuff of this nature be baked into the things that we also have that are less politicized, but still necessary.
Yes, although for the accommodation, those are accommodations for actually in the classroom, you know, where we don't normally meddle if somebody has an underlying medical condition, we sort of refer out to the health center. So, I mean, I can see some differences there, but I also get that there are some similarities. I don't have a good answer.
I really
but-
raised it because I know, like, through the UW system, like WGS task force, that they are raising things like to the system about can students take leave to go out of state to get a service, and can that leave be excused, for instance? And so maybe we just aren't there yet, and like some of those conversations are happening, but that might then lead to some sort of statement if that gets approved or taken up more formally. I mean, so that was some of the context informing that. So sorry for not sharing that.
No, that's fine. And the system work group, it was meeting, I actually am one of Tribun's two representatives on that, and that was the intent of that work group was to sort of field questions from a lot of the campuses. And they do have an FAQ, and they actually, like what I just was talking about in terms of, you know, sort of sharing relevant course material and kind of refraining from giving like health advice is from some of those questions that the system work group has answered. I've not heard precisely this, well, we put a COVID statement in, could we consider this? But in general, that work group, you know, this is consistent in terms of not putting direct statements in about where to access the portions. But certainly this is all moving target, and so good question, good point about the distinguishing between them.
I just want to be mindful of time and checks and where
Yes.
we're at. I know we've been asking
Where-
questions
yeah.
during your initial part, so I think
We're
it's
on
okay
track
to
already. Yeah.
keep going a little bit, but I know people are sort of having questions as they come up, so I'm just acknowledging that we can kind of go into some of our ladder planning with ongoing questions.
Well, I can work also, a lot of the details that I have could also be in the follow-up of the resource material, because I'm just really gonna kind of consolidate and talk about where there is federal protections for data privacy that could be communicated, and I can truncate it if it just makes for better conversation.
And there might be like more of a conversation back and forth about the FERPA question and undergrad research and individuals related to data security and what Donna, you were talking about too.
So on the FERPA HIPAA front, nothing's changed. Medical providers still have an obligation to protect confidential patient health information. So they actually can't release health data in general under HIPAA. And the same, FERPA hasn't changed. We have obligations under federal law to protect student data. And again, that hasn't changed. You know, there's always been exceptions for court orders or subpoenas that meet certain requirements. So, you know, there may be more requests now targeted at abortion-related data now that that's criminal in Wisconsin, but those laws to protect patient health information and student information, nothing has changed in them. And in fact, they specifically mentioned HIPAA, and Sam can talk about that a little bit. So I'm going to turn this over to her to Sam to talk about kind of what other protections there are at the federal level, particularly relating to data security, other than FERPA and HIPAA, which still apply. So.
And while I'm going to talk about this because it impacts it from the federal level, this is not just limited to federally funded research. So I want you to understand that there's some benefit to understanding some of this. So the NIH has privacy certification, which is an added protection. It's meant to shield the reproductive research post-docs. And it's not, it can be used for that. It's used for other purposes as well. It protects identifiable data from subpoenas. It's an added layer, but it is not a guarantee. And again, this is where we get into that, you know, this is where we are today. We don't know where we will be tomorrow. We don't know how the landscape is going to change. It could be used with abortion, fertility data. None of that's been tested in courts though. And that's likely to happen at some point. The certificates protect identifiable sensitive research data from the legal process, making the data inadmissible as evidence unless the participant agrees to the disclosure. It was written into the Public Health Services Act. It originated in the 70s to allow research to study illicit drug use for evidence-based policies, which makes a lot of sense. We would want to protect that data and protect the individuals. The 21st Century Cures Law streamlined the process so the NIH automatically protects human research data using identifiable sensitive information. So we don't want that information to get out. Other researchers can apply for the same protection. So it's not just on NIH funded research with research subjects there. The certificates only apply to research and data protected to protect any information if there is, this is a quote, if there is at least a very small risk that it can be combined with other data sources to uncover someone's identity. And that's what they're trying to protect. The study that must collect identifiable sensitive information, it has to be cleared by an IRB, comply with the common rules, human subject protection regulations, and then no one can be compelled to disclose in a federal, state, local, civil, criminal, administrative, legislature, or legal proceeding for the data. However, the certificates of confidentiality statute allows for disclosure if it's required by a federal, state, or local laws, like communicable diseases or child abuse. Just to name those two. The CDC and the FDA also issue them, but NIH issues the bulk of these certificates of confidentiality. And then an investigator funded by another agency can request, as someone with private funding with a drug company or somewhere else, can request certificates of confidentiality. And there's a process that you can read about it a little bit more on the NIH website. So, and it's actually pretty clear about going through and like looking at the process and even applying for them. So that's one of those resources we would apply afterwards. Getting back to talking about the executive orders that Donna mentioned in the beginning, they strengthen the data privacy protection so that data privacy in searches when seeking abortion, that the FTC has warned against companies releasing that data and misusing that data, so that anybody using this for reproductive health care following that executive order. It also, they requested information on data privacy from mobile providers, that the Federal Communications Commission wrote to the top 15 mobile providers requesting information about their data retention and data privacy policies so that it's consistent with the president's executive order to protect Americans' privacy. There's also their action against illegal use and sharing of sensitive data, that the Federal Trade Commission committed to fully enforcing the law against the illegal use of sharing highly sensitive data, including location and health information contained in fertility and period tracking data. The FTC urged companies to consider that sensitive data protected by numerous state and federal laws, and claims that the data is anonymous are often deceptive. And as you know, for other people who've had concerns about submitting DNA under some of the apps and some of the software around that, I think there's potential for a slippery slope there. Google announced it will automatically delete the records of user visits to sensitive locations such as abortion clinics. The Health and Human Services Office of Civil Rights issued a new reminder to providers about disclosures to third parties, reiterating the privacy rule protections on disclosures of PHI. It can be found on the HHS website. The guidance reminds covered entities and business associates that permissions to disclose are as required by law, requires that a mandate in the law compels disclosure and is enforceable in the court. The reminder continues to be a number of examples that they're trying to use from these executive orders. Congress is also examining additional protections, but the experts still recommend caution, particularly with search engines. Federal law allows internet providers to analyze, share, and sell data on internet use habits. The IRB researchers have already had to comply with the common rule. And the common rule is very well known, especially if you do clinical research. And it allows for the protection of the research subjects' research information. I'm going to talk a little bit about the difference between the primary rule and the PHI. The common rule is it's designed to protect individuals who are research subjects in research projects. The consideration is given to privacy, confidentiality, data collection, maintenance, and retention, and any impact that might have that's physical, emotional, financial, or having any kind of informational harm. The threshold for that is informed consent. There's people who agree that's right, that's through IRB. The IRB has reviewed what the informed consent is. Each person who participates is a subject of the study. And that's where you get into the reimbursement for subjects, because that's where we have to collect their social security number because of tax laws. Because if they receive more than $600 of remuneration in a year, they have to get a W-9 and have to file it as income in their taxes. And that's where it gets a little complicated, because people who are engaged in research studies sometimes engage in more than one, or there's remuneration that hits that. And then you also get the threshold requirement. So the HIPAA, it protects the PHI, the protected health information. And that's for the process of the health information to transfer from one provider to another provider to be able to take care of the patient. There are no exemptions on PHI under HIPAA. You can get exemptions from IRBs or human research protection if it's already de-identified data. So if you're working with surveys and it's de-identified data. So that's really the difference between those two. The implications that are in the future, this is where we really get into it. It's hard to predict. There's no crystal ball. There's no, and it's so, it's such a broad landscape because there's federal and state, and it's all getting kind of commingled and getting confusing in all of this. There are risks to study participants that may be likely today. I don't know if there's going to come into there's going to be this desire to collect, identified data on abortion history. I don't know if there's going to be anything along those lines. We don't know if there's that academics who have publicly spoken about these concerns in their research in the past aren't going to have to address some of those concerns going forward, because most of the research that we do, you want to publish it, it becomes publicly available and your name is associated with it. And while the certificates of confidentiality and the other legal protections listed offer some protection, there's still the advice to only collect what you need and destroy anything when it's on schedule to be destroyed. Delete recordings when they're ready to be deleted, so that you don't have, one of the challenges that we've talked about in research administration our entire career is, talk about email. There's those of us who are email hoarders and we hold on to everything. I'm an email hoarder, I admit it. I hold on to email forever. And so if you're not clearing that out, and there was a conversation that can be auditable, and you may not think about it. I mean, I'm not thinking about it in terms of these issues because this isn't what crosses my email. But what crosses my email is perhaps a conversation I might have with a principal investigator who says something that it could be interpreted as I'm going to go against the regulations regarding this funding, and I'm going to do something my own way. Now, almost always you'll find the next email from me is, let's have a meeting, click. And then it becomes a face-to-face because it's often a misunderstanding of what we can do within the boundaries of funding. But those emails exist. So we think about those things, that we don't want to be collecting and holding on to data forever if it's going to potentially have an impact. And then we can't predict everything that might happen, but one of the things that Donna and I talked about is there is a potential for a shift in faculty. You may have retention and recruitment challenges in states that have abortion laws that are restrictive or not supported by faculty looking for potential positions. You will also potentially see that in shifts of enrollment for students. Students may not want to attend schools in states that are restrictive or make it hard, or maybe be influenced by their families not to do so. Then there also may be a shift in funding, because if you can't conduct the research, or if you don't have access, or you don't have the information, the likelihood of that funding being able to be available to you as a researcher might be limited. And then there's also going to be very likely a disruption, there already is a disruption of medical and healthcare training, because in some states they're having to ship people out to get training in some of the practices to other states, because they're not teaching that in medical schools anymore. So those are the things that I think are much more going to impact on the research landscape in the notes that we've on the talk that we had.
Thank you.
Yeah.
Thank you both so much. Is it okay if maybe we open it up for questions?
Sure.
And I just really quickly, sorry, especially want to note that if there are any researchers that do also identify with doing this kind of research, we're especially interested in allowing you to either share any concerns you have or questions to get a sense of that. Go ahead, Nicole, sorry.
So I'm trying to see if I can get the TV back on here, so you can see who's on here, because we do have a few questions. Maybe not, but Mark Harris has a question. Mark, if you want to try to unmute and speak, I think we can hear you.
Sure.
Yeah.
This is for Sam, and thank you both, Sam and Donna. A lot of stuff, and I know I didn't process it all fully. But Sam, something you said caught my ear. You mentioned the certificate of confidentiality, and you mentioned there are exceptions in things like child abuse and the other category, which seem common sense, but I'm wondering who sets the exceptions and how prone are those to political decisions down the road? Because that's just what I'm worried about is we have in place a whole set of rules, guidance, a whole bit for protecting certain kinds of data that in my mind should never be released, but apparently there are, for some particular things, there are ways that some of it can be. And are those particularly prone to, be honest, political influence, and will therefore vary from state to state? Because if I'm collecting it, I'm really worried about this. And if I'm giving it to an investigator, I'm really concerned about it to the point of probably walking away. So I'll be quiet now.
I invite Donna or anyone else to speak on this as well. The challenge with the federal government is, of course, it changes with every administration. And I've been in research administration for 30 years. So I started when we were at war with Iraq and there was a Bush in the White House, and it was the first time around. And so like I've watched the landscape change, and it changed in the Clinton administration for a push to really increase the amount of funding for biomedical research. And it was impacted by 9/11 and the war with Iraq. So I think that there's always that potential. But I will also say that the people who are in the federal government who are building these rules and these protections do so in the interest of the American people, not in the interest necessarily of the administration. And I've seen frustrating times when I've had conversations with people at the NIH about challenges that were being created in the research administration landscape, and being reassured that what they're trying to do is always in the interest of the public health for the American people. So yes, there is potential. I mean, we certainly saw that over COVID, because COVID became a political item or issue as much as it became a health crisis issue. So there's there's reason to be worried, but until we know the next steps, there's also reason to continue doing the good work that's being done. I wouldn't want it to stop it. I would just tread more carefully.
Yeah, I mean, I'm pleasantly surprised by the more I read on the NIH privacy certifications. But you're right. I mean, it is subject to, if it is required by federal, state, or local law. Now, so the communicable disease or child abuse laws we're following, arguably, if you're in Wisconsin, you're following Wisconsin law with respect to that. And so to the extent a law comes down in Wisconsin that says, you need to disclose anytime anyone tells you they might have had an abortion, that obviously is gonna kind of create a big, basically the NIH certificates will be much less helpful. And I think that's why the key is gonna be to sort of keep an eye on what legislation gets passed in Wisconsin, because it's gonna have a big impact in this area because they're sort of punting back to the states, both by initially in the Dobbs decision, but also by some of these. But if that doesn't happen, this privacy certificate is kind of nice. It adds a layer of protection, and it does, what's interesting to me about it is that it basically exempts out this data from local court actions, right? Where before you could get a subpoena or a court order, this sort of kind of starts to kind of close that hole a little bit in a good way, but it does, all of these things, right, have their flaws, and it's not a guarantee. Again, we think it hasn't been challenged in the sort of reproductive rights abortion setting, and that could happen if somebody tries to rely on one of these certificates. And so again, there is a lot of change. It's just this is sort of a nice protection at the moment, at least, that researchers should think about. And it's nice that it extends beyond NIH research. And Sam looked at some of them. We can provide this when we put together the resources. It seems like they have a pretty good process for applying for it. And
Yes,
a clear process, at least, that we could point people to look at it. And it's not guaranteed. It doesn't apply to all research. It's just like, oh, wow, this is kind of an interesting tool, but with some big caveats.
I mean, their considerations for non-NIH research, where they will do this is if it's collecting usable, identifiable, sensitive information on a topic that's within the NIH mission or an HHS health-related mission, and research information that's collected and stored in the US, which of course that makes sense that the federal government can only protect on the stuff that we're doing in the US. So.
Other questions?
You're welcome to put questions in the chat, or you can raise your hand, and then everyone here can also be part of the conversation. We have lots of thank yous from people in the comments right now, but we do have a question for Maria and Rachel. How has Dobbs affected your research and related scholarship so far in any way?
Could we ask who asked it?
Jen Fishman.
Okay. Hi, Jen. Thanks for coming.
Well, do you have an answer right away?
The question was, how has it affected our research?
Has it affected your research in any way so far, or have you felt like it has not as much?
Indirectly, it's affected it. So I'm starting a new research project where I'm no longer working strictly with infertility, but I'm working on how individuals who either donate their embryos or are considering using donor embryos to build their family, the various barriers that are causing them to, not make a decision on that. And it has made me revise this survey analytic that I've been developing multiple different times, because new issues of personhood, for instance, and the ways in which personhood is conceived in especially the tightened Dobbs era, has just caused a lot more need to rethink the types of questions that we're asking. And I'm working with a community partner that does decision-making counseling around embryo donation. So something that I started with through C21 as a fellow last fall is a survey that has continually now been revised about like 3 or 4 times. And still, we've decided to actually just close out the IRB and start over at this point with a new one. So it's slow research, and that's what I'm learning.
It's probably slowing you down a little bit
Yeah.
because you're having the trademark.
Right.
Yeah, so not directly, it's mostly, I'm at a point of my research that I'm finally writing the book. And so I was just having to figure out how it might be impacting how I'm framing things. So I don't specifically, my research doesn't go into much about abortion explicitly, but it does entail community health workers who are affiliated with an organization that public discourse and mainstream thoughts often only think about abortion. And so when I write about rhetorics of reproductive justice, which I do want to clarify, it notes that we're in a reproductive justice collaboratory, that does encompass much more than abortion.
Right.
And this just happens to be a specific conversation we thought people might be interested in having. But there are some things that happened this summer that actually have impacted how I'm starting to tell the story of the importance of people who do community sexual and reproductive health education and care for children in our communities and thinking about the future. And so it's in an interesting way, kind of connecting with it, but also it's just, as we're all saying, it's an evolving landscape, and as an evolving, like, I'm continuously being engaged with the health promoters I've been working with. So just continually learning about how they work with this and also navigate their own distinctions between what they call C3 and C4 work. And sort of as we were asking this question about whether things are like advocacy work versus our academic work. So people also navigate that in nonprofits as well, of like doing things that are more community education versus political advocacy, and those are separate as well. But yeah, so I don't know, that's my experience.
And I would just add that like what you guys were explaining you're doing is, you know, that's all good. And when we're sitting here, we were trying to brainstorm like what things could you do or think about when you're destroying stuff or whatever. You know, one of my comments was actually, you all are the really are experts and probably have a better sense of what you can do in your day-to-day research that would sort of maybe mitigate some of these potential concerns. And there have been researchers, I mean, in you know, definitely Googling stuff, right, and prep for this. You know, there are researchers out there that, you know, I think I read an article from some Princeton researcher that said, well, I'm changing my research studies because of this and because of concerns about either people being uncomfortable participating or being uncomfortable as a researcher collecting this information when we're not exactly sure what's coming down the pipe because this decision is so new. And, you know, if I talk to any of you specifically about legal questions you have, I mean, the first thing I ask is a lot of questions like, what are you doing? What do you think? Like how, you know, you really, I don't have a good sense of what your research is. And I think these are good conversations to be having, yes, even among colleagues. You know, I'm the lawyer, right? And so I sit here and give the lawyer answers, right? I get invited in. But really, I think there's a lot to be learned just from what you guys are doing on your own projects.
Well, thanks. Well, and as I mentioned, we are graduate instructors. And so like, let's say, for example, this spring, I'm going to be teaching a research methods and qualitative research course. And so just recognizing, bringing in and gaining conversation with our different resources can help me better guide graduate students who, not saying they're all or any of them are going to do work on reproductive health, but let's say one of them wants to, I want to be sure that I can help them know just like the landscape and like the resources.
So Anne has a question.
I wanted to piggyback on what you were talking about this sort of division between education and advocacy, because it came up actually in our program retreat around Trust the Vote, which is next year's programming for us. And the folks that we had brought in from different community organizations said, you know, the 501c3 and the C4 gets, or I can't remember if it's I think it's C4 it's that line is actually blurry too, and that we really have to be careful because it can be politicized really pretty easily about that difference between education and advocacy. And so I just wondered if you can, you know, that it's a little bit of a hot line as well, if we can address that at all.
That for me?
Yes.
I
don't know who wants to do
So
it.
we're neither. We are a state agency and we fall under some other exceptions to the IRS code, which I can't remember off the top of my head right now. So I'm less worried about sort of the IRS piece, but your partner organizations do very much have to worry about that. And in sort of my notes on kind of random questions that I had in case people didn't have the question, I do talk about how you're in the organizations you work with, they need to figure out for themselves what they're doing and can do And they have legal counsel or hopefully access to legal counsel that can help sort of guide them in terms of their tax status. So I'm not really an expert on those because I don't really have to advise on that. We've got, you know, sort of issues and considerations that I think everyone is very aware of as a state agency that impact us irrespective of what the issue is. But we, you know, one bit in terms of the legislation, the legislation is, you know, that's why I kind of mentioned the lobbying rules. Like we have other stuff that applies to us as a state agency that impacts our lobbying registration, both state and federal, and that's all stuff that marketing communications and actually the government relations arm handles. But these are, we will get considerations on that front. And I'm not surprised to hear that and that there's a division there based on how they are incorporated in legislative status. So I just managed to like not answer the question, but
I mean, it comes in like, you know, we're trying to foster as much collaboration as possible with community partners and community-based research. And you know, when you're collaborating with these community organizations and education can be a hot topic, and if that's part of your research process, you know, that's where it would be confusing.
Even in service, because if it's sponsored from an outside sponsor and we pass that through, I mean, if it's a federally sponsored project and there's just a piece of it, they still have to address, and there's this lovely rule called FAFATA, of the Federal Flow Through Accountability and Transparency Act. And Obama put it through when he was in Congress, but then as president, it became like this, you know, it became a big deal. And all of the TARA funds and all the extra money that we got in 2011, all was wrapped into all of this accountability. We had to do all this reporting. And that flows through. So we have to sometimes think about our partners, because sometimes our partners, especially community partners, when you have a mom and pop foundation that's doing some ground, you know, breaking work, but they're like, they don't have the access to resources. They don't have, they're doing their bookkeeping on the back of an envelope with the checking account that may be commingled with something else, because they're not thinking about the fact that they're receiving federal funds to be able to do some of this work. So I've seen this trip up people before. So it just behooves you to get to know who the partners are within your institution. And, you know, like, because if you come and you talk to sponsored projects before, like when you're putting that together, that can be amazing, because we can help build that structure to make sure that everything is okay at the time the proposal goes out the door. Whereas when you get the funding and then you're off trying to figure out how to do this, it can just create delays. When she talked about the lawyer, I'm a bureaucrat. I get to talk about the least sexy stuff, like FAFATA. But that's real. Like, these are the stuff that have unintended consequences, and the work that we're trying to get done. Because it's not that nobody wants to do it right. It's sometimes it's complex.
And we kind of didn't talk about that. That's a good point you raised. Like, obviously, hopefully, if you have funding, you need to be following any restrictions on that funding. And there are other laws in Wisconsin that restrict the use of state funds for abortion or abortion-related services, and that so any of those restrictions would likely come through like pass through of state funds for certain grants, but that hasn't changed. There's always been those restrictions, but it is a good cautionary that for us at least, follow your contracts or follow your funding agreements too.
Well, something related to this, and to your question, Anne, that I had brought up is like it comes to almost a philosophical question of, is what I'm doing political when I have the word justice in it? Am I taking one side because part of my work and the deliverables may actually advocate for one way of moving forward that is not another? And I pointed out, and maybe this is for a future c21 thing on grant finding, I always sit there with the guidelines for the NEH fellowships and how they explicitly say that it cannot be used for X, Y, and Z about advocacy, political activity, this and that. And I really grapple with some questions about whether some work that I might propose does. And so anyway, that's just.
We live in the gray. I'm grateful for the gray. It has given me my career, but we live in the gray. And that's the challenge in all of this. If it was straightforward, frankly, it would be binary, it'd be software. And we put it in and they'd be like, yeah, no, it doesn't follow. And they just spit out an answer. It requires human analysis. It requires human input.
Because of that, I'm wondering, I'm likely we all have some specific questions, and so I, for instance, have a very specific question about advocacy that we don't have to ask right here, but what is the process by which do we just email you? Like, who do we contact, right? What's the first step? Because it's great to have this, right? But like,
Yeah.
obviously, you can't
No,
have it all the time.
that's a
Very good question. So sometimes, and if you think you need legal help, we are 4 attorneys over in Chapman Hall in UWM's Office of Legal Affairs. We work on what we call an intake system. We sort of rotate who gets the new matters to the door in any given week. There are some big caveats to that. When you have a question like that's sort of kind of out of the blue, you should reach out to Bron Nearing. She is our office manager / intake coordinator. She is great.
She's
at
so
that.
responsive.
Ron is on the call.
She keeps track of me and all of us, and it's her job. She does some initial sort of sifting and getting of information. Please tell Bron what your question is. Some people don't like to tell her, but really it's much easier when I call you back if I know what you called about and can like be like, oh, I better pull that out. So Bron is sort of our intake coordinator. We rotate intake. That said, if you have a question right now about this, I'm happy to, and we do some, there's only 4 of us, so we don't super specialize. I have to do a little bit of everything. I tend though to work more in the research related realm. I am kind of our person in our office at the moment on dials for good or bad, which is why I'm here. I'm on the system working group. I'm working with the Madison and system lawyers on that related stuff. And so if it's sort of in this realm, you can reach out to me and I often answer questions if I can, even if it's not my intake week. Don't be offended if I'm like, ooh, sending that through intake this week. We use intake to kind of control our workload, and some weeks I can just have capacity to answer your quick question, or I'm like, oh my God, this is a 3-day research project. So for this stuff coming out of this, I'm happy to answer questions that anybody might have. Right now, you can email is the easiest, honestly. I'm McGee D. We're not hard to find. I'm McGee D at UWM. It's at edu. I say that and I can't even do my own email address right now, but McGee is all you really need to know. But also Bron, if it's something different or something later down the road. Bron's super helpful. Sometimes I tried to punt 2 things to Sam last week and it didn't work. I'm like, it's like pretty researchy to me. And she's like, nope, not me.
We did a lot.
So our offices talk. I regularly work with the Office of Research, with sponsored programs. I talk regularly with, the Research Foundation on research related like projects, industry. So and then for your office, if it's like grant related, I don't know what your actual process is.
I think it depends on where you are in the process. Because if you're dealing with something that's already in existence, you've got an award, you're confused about it, that you can pick up the phone and contact your post-award person. If it's financial, we can, you could reach out. If it's grant related, it's probably going to go through the pre-award grants office if it's turning into a contract. But if you just have a question, feel free to reach out to me right now, because frankly, I'm just fielding things all over the place. And I can get attention and elevate it where it needs to go. I quite often get things now because people have found me and they're like, I'm just kind of a random person. Like my picture's just sitting out there on its own on the website. So we're like, okay, it's like, we'll just reach out to her. I'm supporting Kate while Kate works on the ramp and the ATP project. So a lot of work that I'm doing. I've met 3 of the 4 attorneys here in the 2.5 months that I've been here, because I've just been able to kind of get in and get in the weeds. So I'm happy to escalate, elevate, refer, but you can start with probably any partner you feel comfortable working with in sponsor projects, because it's really on that side of things, it's all about the relationships. It's really about like getting to know your research and what you're trying to do and what your goals are, because sometimes you might have an idea and you don't know where to go and get it funded. You may have funding, you don't know where to go for the question. So really just starting with the person that you're comfortable working with. We all work together as a team incredibly well. So it's been really easy for me to kind of find my way around and find the right person, make sure that I do a handoff if I do a handoff, adequately.
So we only have a couple minutes left. I want to just see, are there any more questions in the chat?
No, we just, I think Casey first, but I know.
I don't want to take the last 2 minutes. I'll take 1 or half. But I'll just say this. I mean, I'm chairing, I'm teaching, I'm doing research in a department that emerged from a political movement. So having said that, what is political and what is fact. It's a fact that there is no abortion clinics available for women. Saying that in the classroom is a fact to me. So, I mean, it's really difficult. In some ways, there are no gray zones. In some ways, the political landscape has shifted and made facts into political rhetoric. And that is the dilemma and uncomfortable aspect for me. I have people from, students who end up in Planned Parenthood asking if they can come and visit WGS classrooms to speak on behalf of the services that they provide, right? To encourage students to go and vote, even if public, any party is mentioned. I'm just throwing out one of my many examples, so to fall down on my desk, that, navigates this discussion about, political and facts and what we can say and do.
And that's a good question. I don't have I need to think about that. Like,
So
there's a lot of, need to think
Can-
about that.
Can I email you?
Yes. But I do need to think about that, yeah.
I have like a half question.
Okay.
But it's kind of like pitching out to anyone who's kind of just been doing stuff for a while. But like the politicization of people and just medicine and stuff like that, like, is that something that has been becoming more politicized as time goes on? Or is this just business as usual, just same shit, different decade?
Business as usual. Comstock laws, it's 19th century, 18th century. I have a lecture that's all about the history of personhood and life and how it's been defined differently since the 17th century. So you'd be surprised, but yeah.
Yeah, so sorry, I know we have more questions, but I do want to be mindful of everyone's time because it's 1:30 right now. So I just want to offer, at least, like I said, I'm happy we all somehow can follow up with people who attended with resources. Thank you so much, Sam and Donna, for all of your expertise and fielding our many questions that we had. We want to, invite people to reach out to us. I hope that's okay as well, if they want to connect or talk more about things and just find community and doing this kind of work and these questions. And just thank you all for your time on a Wednesday over lunchtime.
Thanks for having us.
I have a few extra minutes. I don't know if
I'm
anyone else
happy to
wants
stay a little
while
while
too.
too.
but-
And I
Thank
would
you,
also say
everyone.
that we have these lunchtime C2 Wednesdays, C21 conversations with open slots in the spring. Surprisingly, they got very crowded very quickly in the fall. So it's great that all these different conversations are emerging, but we can hold another one if the landscape changes. It's really, I leave it up to our collaboratory group to call it together if that would be helpful, but we're happy to have another conversation here as well.
Thank you. Thank you so much for hosting us.
Thank you, those in the virtual sphere. We're gonna sign off, but thank you so much for coming.
Thank you.